For this case, plaintiff Lau asserted 2 point-of-law complaints, namely the 14th Amendment and the 1964 Civil Rights Act. Number 1. Concerning the 14th Amendment, it was enacted in 1865, at the end of the U.S. Civil War. The 14th Amendment contained the Equal Protection Clause, which applies to both U.S. citizens and non-citizens alike, with constitutional language that individuals in similar situations be treated equally by the law. The assertion here is that failure to properly educate public school students in the English language was failure by the school district in not treating the Chinese American public students equally under this amendment. Note that this is a constitutional amendment, meaning its language terms can never be removed as outlined in case number 1, Wong Kim Ark, unless superseded or negated by a future constitutional amendment, which is not an easy task, since it requires 2/3 of Congress for approval, then 3/4 of state conventions for approval, then finally signed off by the President of the United States. All of this approval process generally occurs within 5 years, or else ratification has failed and the amendment dies. Also recall that since individual states must approve all U.S. constitutional amendment through the state convention procedure, as a matter of states' rights, state sovereignty, and self-determination within this federal compact, a state legislature convention may also withdraw, revoke, and rescind its prior approval of a constitutional amendment before its formal ratification, as we have witnessed in the failure to ratify the Equal Rights Amendment in the late 1970s. Number 2. Turning to the 1964 Civil Rights Act. This congressional statute was enacted, as you guessed, in 1964. Being the fact it is a congressional law, it can be created, modified, or terminated based on the will of Congress. As recall from our presentation, case number 2, Che Chan-ping, that a prior Congress can never command superior authority to present or future Congresses. Since congressional power and representation is based on American citizens as the current consent of the governed in this constituted republic. In this 1964 Civil Rights Act, Title VI proclaimed, quote, non-discrimination in federally assisted programs. Or, to the legal layman, if you accept federal money in public education, then you cannot discriminate the public students in this regard. Statute explicitly states no discrimination based on race, color, or national origin. If any entity does enact or tolerate discrimination in this regard, then federal funding will be removed from such entity. Literally, the power of the federal purse string. You want federal money? You must comply with federal rules. As a matter of American jurisprudence, federal court commands full discretion on which plaintiff asserted laws they will review. Therefore, the court decided they will only review the asserted law for 1964 Civil Rights Act, Title VI, Non-Discrimination in Federal Funding.